of the Act, after acquittal of the co-accused in the scheduled offences except 25, the allegation of the prosecution of generating proceeds of crime as a result of criminal activity relating to the scheduled offence does not survive. The co-accused in the said FIR has been convicted under Section 25 of the Arms Act. Now, my lord, kindly turn the page, my lord. Yes. Now go to paragraph 8 at page 20. Therefore, the applicant is not required to satisfy the mandatory twin conditions of bail, as he has been in custody for so and so. Turn the page, my lord. The total prescribed maximum punishment of 7 years will be over, etc. He is stated to be in custody in other cases unrelated to the scheduled predicate offences. Admittedly, the said cases are serious in nature. However, that cannot be sufficient ground for declining the present statutory bail application, all the more when he has not been convicted in any of the said offences. Number 9. Even on the merits of the case, after acquittal of the co-accused Vani in all the predicate offences except Section 25 Arms Act, in view of the findings of Vijay Madan Lal Chowdhury, the proceeds of crime in this case have been significantly limited only to criminal activities relating to the surviving scheduled offence under. This drastic limitation has given a severe blow to the case of the prosecution. And my lord is not challenged. So this order of the trial court has become final. Now, my lord, kindly.
That's a special cell FIR.
Mr. Luthra, why you are acting as Mr. Anil Kaushik?
I'm not very sorry. I realize my mistake. Not rightly put, and I stand corrected.
His energy is absolutely uncontrollable.
Yes, Lord. But I'm also rightly corrected, Lord. No, Lord. I got a little confused because he said it's in the predicate offence, and I suddenly got a little bit of a shock. That's why.
That's a finding in the order he is reading. He is not reading from his own.
I know, Lord, but it's in the earlier case of 2007. That's all.
This is probably to show the period of custody. So 7 years in that case was continuing till 7/6/24.
Yes, Lord.
What argument is forthcoming from counsel is regarding total custody of
But that
almost 3 decades. That's
no,
what
Lord,
he's arguing.
it's 13 years. It's 13 years, and we put that down.
Yeah,
6.5 years in this case, not in the other case. That's the rest is all PD, etc. Put that.
Yes.
Now, my lord, page, my lord, 5.
Of this.
Bottom of the page, my lord. Now I'm going to, my lord. This is of the written submission. Middle of the page. 7/6/24. So, my lord, only when Vani was granted bail, the petitioner was arrested on so-and-so 19 in the present NIA case to prevent him from being released. The allegation of terror funding is the main allegation in these proceedings. Now, my lord, go to gross delay. And I need to show you, open to that page here. Page 6, my lord. Yeah, we'll come to that. I'll give you, lordship, the chart. We've got it there, right? Yeah. Now, my lord, 30 witnesses examined out of 248. That is the latest? And my stand is, my lord, I maintain that I have not delayed these proceedings, and I've got the chart given by the Mr. Luthra's client himself, not a single day by me. 72 dates of hearing over 45 months, average 1 or 2 hearings a month. 16/3/22 charges were framed. It took 3 years to frame charges in this case. And now, my lord, we are 3 years after that. Only 4 adjournments sought up to today. 2 years after that. Oh.
4 years.
4 years, yes, my lord. Only 4 adjournments sought by all the defense counsel together. And I'll show you, lordship, why they do that. Because they are given documents by the state on the spot in court, and they say we need a week's time to look at those documents. All the defense counsel together, not a single day's delay by me. Now show me the page where that is there. No. Page is just. Yeah, my lord, go to, my lord, page 20 of the counter. I'm going by this counter alone.
Reply on behalf of the SLP.
Yes, my lord.
NIA.
Yes, my lord. Yes.
Page 20.
Page 20. Yes, my lord. These are the reasons for adjournment. 31st October
25.
25. Then we have an order to show. Right? Lordship has that at page 20? Yes. So, my Lordship, 16/7, 20th 8, 31 8 on page 20.
Yes,
Adjournment sought by defense
Charge sheet was filed on what date?
March 22.
No, sir. That was charges claim.
Three charge sheets, if I may just point out, he was not in the first charge sheet which was filed on 18th January 2018. The first supplementary was September 2019, and his charge sheet was 4th October 2019.
Mr.
Thereafter,
Vikram.
not.
So these documents which you have filed are after 3 years of the charge sheet being filed. You have to take that into
Which
account.
documents, bro?
These documents which are referred to in the list of documents, 8/7/22 order sheet, the documents which are referred to have been
I
filed
just see
3
that.
years after filing of your charge sheet.
For admission denial.
Oh, whatever.
No, Lord, I'll tell you, Lordship, why.
Whatever.
No, Lord, the answer is simple. I must tell you, Lordship, Lord, March 20 to 22, there was COVID. So that became an issue, Lord. For 2 years, things were at a standstill. My Lord is absolutely right. Lord, kindly just see, charge is framed. The charge arguments begin in 21 and Lord.
Admission denial takes place before charge or after charge? Generally,
Lord.
usually.
Lord, usually, Lord, it can be before charge. Lord, I can't disagree with your Lordship on that. But here what happened was the consensus at that stage was not two things.
In any event, there are three adjournments by defense counsel over a period of 1.5 months.
Yes.
On the issue of admission denial, and the list is of date has been filed in July 22, 3 years after filing of the charge sheet. List for admission denial of
Yes,
charge
Lord,
sheet.
these were documents already on.
All right, we understand, sir. But which documents you want them to admit or deny? They were identified by you after 3 years of filing of charge sheet.
No, Lord, I can't disagree with that. I'm not disagreeing with that, Lord. All I'll say is.
That's the only comment we
Now,
wanted.
Lord,
That's-
kindly see page
Because I'll just add one thing,
611.
Lord.
Okay.
Just wait 2
All
seconds.
right, Mr. Gonsalves, just wait a minute. We asked him to
Yes,
respond. Let him.
yes,
let him
May
say.
I just say this?
Yes.
Lord, there was a consensus at that stage that to cut short the trial and cut short the period
Absolutely.
trial,
That is mandatory.
we will give a list of documents. Now we gave that list of documents, and thereafter they
The
said
only
they.
contention is that you can't use this so-called period of delay or can't attribute it to the accused. That's all.
But no, I tell you what, Chibai, after 3 dates, they said we don't want to do it, and that is where the matter ended. So we went into trial. That's all I wanted to
This
point
is
out.
the only period of 1.5 months which is being referred to by counsel for the.
Lord, I put down every list, Lord, as to what happened, and that's the reason. And thereafter, I've given you on the last occasion, the last order also.
All right. That's
Now, my Lord, see the order at page 611.
Mr. Gonsalves was only trying to emphasize that there has been no delay at the end of the defense. Whatever delay is there is at the end of the prosecution,
Lord,
either by not producing the witnesses or by seeking adjournments.
Lord, my response is please see that chart. That's self-explanatory as to where the delay was. I will not comment at this stage. Let him argue. The chart says where the delay was, or if there was no delay, that will point out.
At 611,
611 of.
the same,
Lord,
count,
just
same count.
All right.
The details are.
Now just see, my Lord, the order here, middle of the page. Lordship has it.
Page?
611 of the same counter.
Yes.
Six one one. Okay.
Copy of the relevant orders of the London Special Court after decree Order
This is
on
the
payment of
order
charges.
of the trial court dated 6/4/24.
611.
Can't be 611. 611, you are talking of PDF or what?
No, counter affidavit.
Counter affidavit.
है ना?
The
682
PDF will
का
be
है ना?
615.
It is
PDF will be
page
615, my lord.
1212.
Yes,
PDF.
Is order dated 8th April 24.
6 April 24.
6th April 24, yes.
Yes.
बीच में कुछ पेजेस पे ऊपर पेजिनेशन नहीं दिख रहा था इसके ऊपर।
Lord, maybe PDF 615. Just see that, please.
Let Mr. Gonsalves complete his arguments.
611, middle of the page.
Yes.
It is submitted that this person, PW17, is a witness to search and seizure. And there are about 53 diaries specified in the search memo was also seized. However, on behalf of the NIA, it is submitted that being the voluminous record, copies were not provided to the accused persons. On behalf of the accused, it is submitted that without inspecting the record, they would not be able to cross-examine witnesses. In this regard, it is submitted that on the next date of hearing, at least 2 weeks prior to the next date of hearing, the NIA shall facilitate the inspection of documents sought to witnesses, etc., etc. So documents not given, then on the day we say, okay, give us, and then 2 weeks, my lord, 3 weeks adjournment takes place. But from our side, my lord, I maintain we did not delay the trial for a single day. Now, my lord, kindly go to page 6 at the bottom
6 of the counter again.
of no, my lord, now of the note. Sorry to go back and forth, my lord. About an hour, my lord, but I'll finish quickly. Everything is ready.
More than an hour.
Yes, but 1 hour, 1 hour. Not
1 hour.
Yes, my lord. And I'll finish quickly. I need to complete the argument properly. But I'll finish quickly. I won't be meandering.
But if we
anywhere.
say that we are inclined to grant you bail, still you will take 1 hour. Mr. Luthra,
What do you say to delay? Your 207 was not complied till 6/4/24, sir.
Lord, may I just point
Read the
out-
order sheet dated
Yes.
6/4/24
But
and tell
let's-
us whether you had complied with 207.
Lord, the answer comes simply in the CRPC. May I just point that?
Yes, yes,
May
please.
I just point? I understand what your lordship says, but the answer is here. Voluminous documents, inspection can be done. Lord,
The inspection can be done. When did you provide them the opportunity, sir?
Lord, never,
For the
we
first
never
time.
refuse, Lord, may I just,
You said that we have not provided for the first time.
my lord, can I just?
You are dealing with an accused in custody,
My
not
lord,
an accused on
can I-
liberty.
Can I
Yes, please.
seek to answer that for a moment?
Yes, certainly.
My understanding, Lord, is this.
Let us see 207 CRPC DGP. At what stage are you supposed to give that opportunity or offer that opportunity? At the stage of 207 compliance
Absolutely,
only?
Lord. I'm not.
And when is that supposed to
My
be
lord,
done?
let us see that.
Before
order.
committal?
My lord, let me see
Let us
that
read
order
it,
with
sir.
you again. Let me see that order. I understand you putting a query to me, but let
Yes,
me.
please read the
let
order
me-
at 611.
Just a moment, Lord.
Yes,
we
please.
just come to.
We'll assist you PDF 1209.
I have it, Lord. I have it open. Don't worry, Lord. I'll come to it. Now, please come to 611.
Yes, please.
Lord, PW17 Anup is examined. It is submitted that this person, PW17, is a witness to search and seizure There were about 53 diaries specified in the seizure memo were also seized. So all these. However, on behalf of NIA, it is submitted that being the volume of court, copies were not provided. No, I'm not. I beg to add.
Yes, proviso, second proviso.
Yes, Lord, we'll come to
Yes.
that. Now,
So when were you supposed to do it,
my
sir?
Lord, I'm giving
This
you a lot.
offer of
Inspection.
inspection, when was it supposed to be done?
Lord, let us just then, Lord.
Yes, please.
Yes, so Lord, please come to 207 with me.
Yes, please. There is no dispute on the aspect, Mr. Luthra.
Lord,
Please, let me complete. Allow me to complete
not at all,
the
Lord.
sentence, please.
Lord, I will
That
not be.
207 has to be complied before 227. No dispute.
No dispute, Lord.
Now, when did you offer for the first time?
Lord, the answer, if I may give you, will lie in the law. If I may read the.
Yes, please read it, sir.
Yes.
Certainly.
Now, that's all I was trying to do, Lord. Please come to 207, Lord.
Yes.
And please see the first and please read the last proviso to Roman
So
5.
first, let us see the starting lines of 207.
Of course, my
What
Lord.
does it say?
Of course not. In any case where the proceeding has been instituted on a police report, next word, the magistrate shall without delay.
Without delay.
I agree with
Without
your
delay.
logic, but not who? The magistrate.
Yes, but
The
whether you
magistrate.
place them on record or not.
Everything was there.
Did you file these diaries? Are you ready to make a statement?
I'm
They were
quite
a part of court
confident.
record?
I'm quite
Are you
confident.
sure?
Lord, I will just verify 1 minute. Allow me. 1 minute.
Please.
Lord, they're all on the record.
They were filed along with the charge sheet?
Lord, they were
53 diaries?
Lord, they were, and I'm willing to, Lord, because I must tell you, Lord.
Yes, please.
I've taken instruction of the officer, yes. To my understanding, not to my recollection, when we argued charge, they were there, but he's saying they're there. Just a minute, sir. Just please sit down. Please. Yes, sir. Document number, because I also want to be accurate.
Yes,
Your
yes,
Lordship is
certainly,
putting a very
certainly.
pertinent question to me. I need to be accurate. Give me a moment. This would have been filed with the first charge sheet. First charge sheet, right? Arey bhai, first charge sheet. Now, this will be with the first charge sheet. I have a feeling.
Mr. Luthra, the very beginning lines of order dated 6/4/24 make the things clear. Please read that.
Lord, I've read it and I missed
No,
it.
we have missed something.
Right,
Please. You also, and so also us, we have missed something. Please
Lord?
read.
I know what your Lordship is saying, Lord. That I know what your Lordship is saying. Allow me a moment. Just give me a moment. Let me just come to that document. But your Lordship is now wanting to just. It is submitted that PW 17.
Property was never produced in the court.
Please
This was
examine-
case property.
My Lord, just allow me a moment. Let me just verify that. Let me just verify because my understanding
Certainly.
was they were lying. They were not physically in the court. They were lying.
With the NIA.
Lord, this is something. Can I just answer? Your Lordship gave the answer. No, Lord, that answer is mine. That will not be yours.
Yes.
Lord, I'll just verify if it is in the Malkhana or it was in court. That's all. That's the issue I have to point out.
No.
That's the issue, Lord. If it's lying in court, it's lying in court. If it's the court Malkhana, then I can't be blamed. If it is in the NIA Malkhana, I will completely abide by what your Lordship says. But let me just get that verification. It'll take a moment. Would you? Lord, the challenge is, unfortunately, and I must tell your Lordship, is that I don't think they've filed a copy of the main charge sheet.
Assuming you had filed it,
List of witness
but still
documents.
nevertheless the magistrate failed to comply with 207 second
Who is
proviso.
prejudiced?
Now,
Maybe you may not be at fault,
My Lord,
but then the accused is being put to unnecessary adverse
my lord.
situation.
my Lord, may I just say this? I'm not, those orders are not here, but
If even the charges were framed without referring to these documents, sir, what would be the fate of your case? Please see.
No, Lord, there's a little difference. Lord, if I may just say so, Lord, just, Lord, this would be a seizure.
Mr. Luthra, the niceties which you are trying to dwell upon may not be very clear to your associating counsel or even to the IO. It's a fact. These things, with due respect, would be.
No, Lord, I'm just trying to verify. Lord, I'll verify this. I don't want, I'll give you a lot.
All right, Likhe heard.
Lord, I'll
Mr.
give you a
Colin
lot.
Gonsalves, Learned Senior Counsel for the petitioner, and Mr. Siddharth Luthra, Learned Senior Counsel appearing for the respondent, State of NIA.
NIA.
NIA. Likhe bail granted.
My Lord, just hear me on two
All
things,
right.
Lord. Hear me on two things, my lord. Lord, two things, my lord.
You will get a detailed order, huh?
Lord,
We will not touch the merits.
Lord, may I just say this? I understand what is falling from your lordship. Just, can I have 3 minutes and just clarify one thing?
You can't explain the delay, sir.
Next case.
Forget about conduct. Forget about
can I
responsibility.
explain the-
Just wait a minute, please. Forget about liability. Forget about responsibility. Who was responsible for the delay? Fact, it is delay. 7 years in the previous case. While that is going on, you registered this case. Please wait a minute.
Yes, of course.
And he continues to remain in custody. What is the total period? 14 years.
Can I now?
No less than 14 years,
Lord,
please.
can I now answer that
Very
for
well.
a moment?
Yes.
13 years is no problem, Lord. That's a separate issue. Now allow me 3 minutes, Lord, on this.
That's all right. Uninterrupted 3 minutes. Seamless.
No. Lord, I welcome interruption. I learned.
No
Why should I not?
interruptions from the court. You have your 3 minutes
Lord,
by the clock.
2019 is when he's arrested. So let's keep that in mind. Now, 19 is arrested. We have COVID for 2 years. Not during COVID, we start arguments. Now, just see that chart for a minute on dates because my friend read.
When is the FIR registered or when is
Lord, FIR is 17, but he's
17.
he's not arrested then.
He is not arrested.
He's arrested
When does
in
his name
19.
surface for the first time
Yes.
in your investigation?
Yes. Now, my
He
lord,
was already in custody.
In custody.
Why did you not take him into
Lord, he was not in my custody.
not in your custody, but you knew he was in judicial
My lord,
custody.
my lord, he may be in custody in some other case. We
Lord,
only come to him when
You
allow-
don't take him into custody in this case and you say that no, I will take him only after he is likely to be released there.
He was named first charge sheet. You did not involve him in the first charge sheet.
Lord, when we have
Arraign him in
All
the
right,
first
Mr.
charge sheet.
Luthra, 3 minutes over.
my lord, your lordship
Next.
said uninterrupted. Now, allow me. Lord,
Uninterrupted because you don't have answers for
allow
simple
me,
questions.
Lord, allow me. Just do me
Very well, next
just
case.
for my satisfaction. Can I ask you for one thing? One, Lord, just look at that counter and just see the chart. I understand what is falling from your lordship. Please see that. My lord, Justice Mehta rightly pointed out the dial. Now just see that for a minute and please come to the chart, if you don't mind, from page 21.
Of
Lord, of my counter. In fact, 20 of the count. Please just note the date, Lord. Once we started the trial, how we've been acting. Just see that. There has been one problem which arose in this case, which I will answer to your lordship. Lord, please come to, after the admission denial, please come to 211, 1 examined, 311, 1 examined, 4 examined, 1 examined, and this will go on. So we've been getting them examined diligently. Now, what happened, Lord, was thereafter, come to the next page, 4 September, defense order adjournment again. Then, Lord, kindly just come to the Lord 6/4/24, next date. In fact, Lord 19/12/24, then 6/4/24. All of these are all adjournments taken. Now, Lord, the challenge arose was in 23rd October 24, and I must tell your lordship. One gentleman, A18, Abdul Rashid Sheikh, became a member of parliament. The court ran into quandary whether this is an MPMLA court or not. 4 months were spent when we went to the High Court, got a clarification. We both sides agreed that we'll go to the High Court and get a clarification. And finally, that clarification came, Lord, because this went on, Lord, awaiting the matter while bail applications were being taken up.
Mr. Luthra suggests stringent conditions, whichever you desire to be incorporated. It's been sufficient enough. There is a limit to everything.
Lord, may I just say this? Lord, may just allow me. I'll because my learned friend.
You put out whatever conditions you want to make.
Pass on a note to the court master.
I'll give to them.
Yes, very well.
Lord,
Next case.
Take
Lord, just
care of
one
the
thing.
things that
एक second, yeah. Lord, my learned friend, my young colleague wanted me to point out that JKFTP, which is that banned organization, the website is still operational. That's all. So the issue is the second point condition will matter.
You
But
put all the stringent
all
conditions as you
conditions
like.
which you
all
want
right,
to
Lord,
be
I will
incorporated.
give it to the learned court master. I'm deeply obliged for the hearing.
Very well. Thank you.
Lord, may just keep in mind.
Always
that-
better to have Mr. Luthra in the second half. In the morning, he is so fresh. He can beat Mr. Anil Kaushik.
Lord, I have taken the hint from my Lord Justice Mehta. I will not be a jumping jack in future. Lord, just one request. On this matter, I just want to keep it with your lordship that there are other accused whose bails are pending.
Yes, yes.
So, my lord may just. be kind to us in the sense that this does not impact others.
Very good.
That's I'll give that. We'll get the condition, we'll give to the.
Give it. During the course of the day, you can give it.
Yeah.